Welcome to the other side of Letby. In episode 79, we're going to look at a theoretical situation in Lucy's life. Every time we hear anything about Lucy Letby, people always say, originally from Hereford. Now, I have no idea why they say that, as if it matters. But let's imagine that Lucy was from Hereford in Texas. So the Lone Star State of Texas has a town called Hereford, and it has a population of about 14,000. So it's a small place. Now, had Lucy been born in Hereford, Texas, and wanted to become a neonatal nurse, the cost to do so, as well as the opportunity, would be similar to the UK. But that's where the similarities end. A neonatal nurse like Lucy Letby, or the average wage of a neonatal nurse in Texas or in the United States, is approximately $100,000 to $112,000 a year, or $51 an hour. So at entry level, that starts off at $77,000 a year and rises with experience to about $127,000 a year by the 10th year of experience, and as high as $164,000 a year with 20 years experience. So in Austin, Texas, for instance, one of the big cities in Texas, an average wage for a NICU nurse is about $1,700 a week. And if you reach the equivalent of a neonatal nurse practitioner, so that would be an advanced nurse practitioner in the UK, you could expect to earn up to $159,000 a year. So for the sake of argument, let's say $130,000 a year. And by now, Lucy would be 10 years into her training and experience. So that's not an unreasonable figure. In economics, there is a term called PPP, or purchasing power parity. And that's a method by which you can compare a wage in America to a wage in the UK. So if you use the current PPP to compare the US dollar to the pound in purchasing power parity, that would mean that Lucy would now be earning about £100,000 a year if she lived in Hereford, Texas. In the UK at the moment, the maximum that an advanced nurse practitioner could earn is roughly £60,000 a year. So Lucy would be £40,000 a year better off had she moved to Hereford, Texas, and trained and worked there. But she would have been better off for many other reasons. Now, the reason for this podcast is that someone, and I cannot remember who it was, but I think it was the Jolly Contrarian on Twitter, brought up the subject of what's known as the Dibert Rule, or Rule 702, when it comes to giving expert testimony in a criminal case in the United States. Now, whereas Lucy Letby would have been charged under state law and not federal law, Hereford, Texas has its own Rule 702. So let's have a look at Rule 702 to see how it may have impacted the conviction of Lucy Letby, the trial of Lucy Letby, and the likely outcome of the trial of Lucy Letby. So the Dibert Rule refers to a standard set by the United States Supreme Court in Dibert versus Merle Dow being a big pharmaceutical company. And this was back in 1993. And the purpose of it was to determine the admissibility of expert witness testimony in federal courts. Subsequently, this got translated into all the state courts in America, their own version of it. But it is essentially the same thing. So Rule 702, or the Dibert Rule, would have applied to Lucy Letby in the state of Texas. So under this rule, the trial judge acts as a gatekeeper to ensure that any and all expert testimony or evidence admitted is both relevant and reliable. If we look at the relevant part of it, Well, of course it would have been relevant because the person who participated in the investigation of Lucy Letby, which wouldn't have happened in the United States either, Dowie Evans, made it relevant. So we will look at the Daubert rule in terms of its reliability. What does the Daubert rule, or Rule 702, say about reliable expert evidence? Now, to put this into context, we will return very briefly to the Court of Appeal ruling that denied Lucy Letby the right to appeal. And we will recall that there were 4 grounds on which Lucy Letby sought to appeal her conviction. Ground 1, 2, 3, and 5. And ground 1 was that the judge was wrong. That was Justice Goss was wrong not to direct the jury to disregard the evidence given by Dr. Dowie Evans, and was wrong to admit further evidence from him. Ground 2 was the judge was wrong to reject the submission of no case to answer made by the defence at the conclusion of the prosecution case. And the third ground was that the judge was wrong to direct the jury that they did not have to be sure of the precise harmful act or acts on any given count on the indictment. And we'll just put out of the way ground 4 for the time being, because it's separate to this, and that was that the judge did not take the correct course of investigating a potential jury irregularity arising out of a complaint first made to the court on the 2nd of August 2023. So let's just have a quick look at that one first. So on ground 5, that is paragraph 193 of the Court of Appeal ruling. And it says that ground 5 raises a truly discrete issue. Leave to appeal against conviction is sought on the grounds that the judge did not take the correct course in investigating a potential jury irregularity arising out of a complaint first made to the court on August 2nd, 2023. Mr. Myers did not put this ground at the forefront of his submission, and rightly so in our judgment. In short, the decision made by the judge in this connection were case management decisions, which he was quite entitled to determine in the way that he did, and we do not consider the contrary to be arguable. So Justice Goss was entitled to give the opinion he gave. So the judge gave 2 rulings, the first of them on the 3rd of August and the second on the 10th of August 2023. And the matter arose when the jury had retired to consider their verdicts on July 10th, 2023, and on August 2nd at 15:09. Isn't it amazing how they can be so accurate about things when they want to be? At 15:09 on August 2nd, the court received an email from someone. A name was given, who we shall refer to as KR. The jury had been in retirement for 13 days. The events thereafter and the judge's reason for the course he decided upon are succinctly summarised in the judge's first ruling as follows. The trial is in its closing stages. The jury was sworn on the 10th of October 2022 and is considering its verdicts on 7 charges of murder and 15 charges of attempted murder of neonates in the Countess of Chester Hospital, Chester, allegedly committed by the defendant in the course of her duties as a neonatal nurse at the hospital between June 2015 and June 2016. This is a very high-profile case, which has been reported by many mainstream media organisations over its duration and has been the subject of a very large volume of communication over social media platforms. As is not uncommon in such cases, there have been a large number of unsolicited communications with the court and those representing both the prosecution and defence from members of the public containing, information about the case. The jury retired to consider its verdicts at 1300 hours on Monday the 10th of July. Their deliberations were interrupted between the 17th and 21st of July and were resumed on the 24th of July. The jury did not deliberate on the 31st of July. At shortly after 1500 hours yesterday, 2nd of August, during the 13th day of their deliberations, following up a phone call to the court office, an email was received from a member of the public to the effect that she had a cafe and a customer who had attended the cafe a few times, who the email identified by their first name and the description, and who was a juror in the case, had been talking about the case on a few occasions, describing some of the evidence and events, and, quote, that the jury had already made up their minds about her case from the start. And the email hoped that this would be passed on to the defense attorney. Now, there was considerable investigation by Greater Manchester Police into the origin of this email, because the emailer didn't respond to attempts to establish communication further. And at this point, the defense asked the judge to interview the juror that was named and described by the cafe owner. The prosecution, as you would imagine, opposed the suggestion that the judge interview the juror, and the whole thing was put down to someone trying to derail the trial. And the net result, when you read this, was that Justice Goss didn't interview the juror. So when I read this, what I see is that no one in the trial process doubted the veracity of the description of the juror, including the name, and Mr. Justice Goss also said that he had had the benefit of observing the jurors over 9 months, and the juror in question had been assiduous in his attendance and had clearly paid very close attention at all times to the evidence and to counsel's addressing and my summing up. There is no material other than the content of the email to doubt that he has done anything other than faithfully followed my initial directions and set out the standard documents given to every juror as to their responsibilities as jurors, including not to talk or to communicate in any way with anyone or anything about the case other than fellow jurors when they are all together. So the conclusion we can draw from all of this is that this juror did exist, had been identified by an unidentifiable source outside of the jury, and Justice Goss didn't disagree with that because he referred to the juror himself. So it seemed as if, as I read it, in my opinion, that the judge did know who the anonymous emailer was referring to. So how would that play out in Texas? It's hard, of course, to know for sure, but there is in Texas state law a provision called Article 3622, which would have required the judge to investigate this more thoroughly, and that would have been mandatory. And if any violation was proven, that would have led to an automatic presumption of harm to the defendant. So it's likely, reading Texas law, that if this person was investigated by the police or the court in Texas and admitted that they had a conversation in the cafe, even if they denied the content of the conversation, the burden of proof would switch to the prosecution that this had not harmed the defense. So, for what it's worth. But let's return to Dybert. Now, in order to pass the Dybert rule, or for your evidence, expert evidence, to be admissible, it has to conform to the following standards. And these are its testability. And we have talked about this before in terms of falsification, that the fundamental philosophy of science is that an assertion, a hypothesis, a theory is subject to falsification, not proof, falsification. So the expert's methodology must be scientifically validated and falsifiable under the Dilbert rule. The theory or technique should be published in peer-reviewed literature. So that's not a matter of Sandy Bohan peer-reviewing Barry Evans. No, it has to be published in peer-reviewed literature. The methods, known or potential error rate must be disclosed. So we have to know how reliable the test is, how often it fails, what is the error rate. Controls and standards for applying the methodology must exist. And finally, that the theory and the technique should be widely accepted in the relevant scientific community. Now, it may be widely accepted only as a theory, but it has to be widely accepted. And how does the UK measure up to this very strong standard of producing facts through expert witnesses in criminal proceedings? So before we go through this, let's look at the indictments quickly again and the convictions. So BBA murder, June 2015, embolism. BBB attempted murder or embolism. BBC, June 2015, via nasogastric tube. BBD murder or embolism. BBE murder, acute bleeding or embolism. BBF attempted murder, insulin poisoning. BBG attempted murder, overfeeding with milk. BBG attempted murder, overfeeding with milk. BBI via nasogastric tube / embolism. BBL attempted murder, insulin poisoning. BBM attempted murder, embolism. BBN attempted murder, throat trauma. BBO murder, injury to liver / embolism. BBP murder via nasogastric tube. So straight away we can say under the Dilbert rule, BBC, BBG, BBI and BBP would not have made the docket. So based on the expert evidence witness for those cases alone, they don't meet any standard that's set out in the Dilbert standard. There are 0 cases in the world where babies have died by injection of air into a nasogastric tube, and therefore there's no peer review for such a method of death. There's no error rate, there's no methodology description, and therefore it isn't falsifiable. If we look at the 2 insulin cases, because they used immunoassay tests and they only used one, and because the immunoassay test was taken while the baby was receiving dextrose, it would be, under the Dilbert rule, inadmissible as evidence, because we can easily say that the error rate is unknown, but possibly through the roof. And in order to prove insulin poisoning, you need a lot more information than that. Now, we remember that both BBF and BBL had a single immunoassay test made by Roche called the ELISA, ELISA, insulin and C-peptide immunoassay. So to remind you again how these things work. So ELISA, ELISA, stands for enzyme-linked immunoabsorbent assay, ASSAY. So the test uses these special plates with tiny little wells, and these wells are coated with antibodies that specifically grab onto insulin or C-peptide molecules, like a key going into a lock. So when your blood sample is added to these wells, any insulin or C-peptide present will stick to these antibodies. That's the theory. Then a second antibody is added to the test, but this antibody is connected to an enzyme. Now, an enzyme is simply a chemical that speeds up a process but doesn't take part in the process. So in other words, the enzyme can make the chemical process inside the body more efficient, but the enzyme is not going to get used up or disappear in that chemical process. So it's like a teacher herding kids onto a bus. They're going to herd the kids onto the bus a lot quicker, but the teacher's still going to be there at the end of it. So when you add the enzyme-linked antibody to the insulin C-peptide-linked antibody, you create a sandwich. And then you have to wash away everything so that you're only left with the original antibody that picked up the insulin C-peptide and the enzyme-linked antibody. So theoretically, they would be one-to-one matched. Then you add what's called a substrate. So this is something that's going to react specifically with the enzyme. And when it reacts with the enzyme, it produces a color change. So the color change of the enzyme is then used as a proxy for the presence of either insulin or C-peptide. So what you're really measuring is the reaction between the enzyme-linked antibody and the insulin C-peptide-linked antibody. What you're not measuring is insulin or C-peptide itself, merely their chemical reactions with the antibodies. So would this pass the Dibert rule? Absolutely not, because recent studies show that the Roche C-peptide immunoassay demonstrates substantial discrepancies compared to other analyzers, and the mean bias is 38.6% when compared to other systems. So that is a very high error rate compared to what you can achieve. Therefore, your defense barrister in Texas would simply say this immunoassay has too high an error rate to be relied on as forensic evidence. Then we have the problem of standardization. Despite being traceable to international referencing reagents, so these are the chemicals that are used in these little sandwiches, Roche immunoassays show significant differences between analyzers in the entire concentration range, especially when you're looking at C-peptide, which means that from laboratory to laboratory, you're going to get a different result, or at least you can get a different result. So no standardization won't pass the Dibert test. In the Texas courts, they insist that the technique must have been properly applied on the occasion in question. Well, you cannot really say that's the case for one test. If you ran the same sample 3 times through the same piece of equipment, or even better, through a different piece of equipment, and you got the same result, then you could reasonably say that a single sample provided a robust result. But a single test from a single sample would fail the Dibert standard. But we know also that in actual use, in other words, when you're using these immunoassays for the purpose for which they were designed, which is the management of an illness, not as a forensic test, the literature specifically states that these discrepancies impact clinical diagnosis and comparability of test results, which means that if you're using this test only to manage a disease, again, it's going to vary from hospital to hospital. So it wouldn't be regarded as a clinical standard on its own. So let's look at how this might play out in Texas, and we'll look at it in comparison to another case. And this case was Hernandez versus the state of Texas. And this case involved the admissibility of scientific evidence under Texas Rule of Evidence 702, which is the Dibert ruling, and Kelly v. State. And the question at issue in the appeal was, must a party seeking to introduce evidence of a scientific principle always present evidence sufficient to satisfy the test of Kelly v. State, regardless of the particular scientific principle? And the second question in the appeal was where either the Court of Criminal Appeals or Court of Appeals has determined the validity of a particular scientific principle and the technique applying that principle, must a party subsequently seeking to introduce evidence based upon that scientific principle nevertheless satisfy the first two prongs of the test of Kelly v. State. And consequently, question 3, did the Court of Appeals in this case err in holding that the trial court had abused its discretion by admitting evidence of the result of a urinalysis test of the appellant's urine sample? And the court ruling was no, no, and no. So what does all that mean? The appellant, in this case Mr. Hernandez, had pleaded guilty to the possession of marijuana, and the trial court placed him on a probation for 10 years. Almost 10 years later, the state filed a motion to revoke his probation, alleging that the appellant had failed to avoid the use of controlled substances and had tested positive for marijuana on January 28, 1999. And at the hearing, Mr. Perez, a laboratory technician, testified that he tested Hernandez's urine for the presence of marijuana using a machine called an ADX analyzer. The test result was positive, and Mr. Perez, the lab technician, testified that he had worked as a urinalysis lab technician for 2.5 years. He explained that he had 32 hours of specialized training on the ADX analyzer and about 2.5 weeks of extensive training on the job. And when he was asked how many of these analysis tests he performed, he replied, "I couldn't say, it's just so many." But on cross-examination, Mr. Perez was asked to explain the scientific theory behind the test. And Mr. Perez answered that the machine uses what you call fluorescent polarization amino acid technology, which deals with antigens and antibodies that are in the blood system. So it acts like an immunoassay. And then he blathered on about how the test worked, and he quoted the laboratory and all the rest of it. And when he'd finished, the defense cited Rule 702, or the Daubert Rule, to claim that Mr. Perez didn't know what he was talking about. And the Court of Appeal ruled that, in general, tests that had been accepted by other courts over a period of time, in other words, tested in law, tested in reality, didn't necessarily have to prove themselves at every new hearing. But at the same time, the court wasn't allowed to simply accept that evidence as being true, and that every court in Texas must use a 3-pronged reliability test, and that is that the validity of the underlying scientific theory is correct, that the validity of the technique applying that theory is correct, and that it is correct in every specific case. So the burden falls squarely on whoever introduces the scientific evidence to prove its reliability. Courts simply can't take scientific evidence at face value. In other words, Dowie Evans says, then that's good enough for the jury to hear. The judges in Texas have to act very strongly and proactively to prevent the jury hearing evidence that is what the appellate courts referred to as black box evidence. So that it's perfectly reasonable for any defense attorney in the state of Texas to question the validity of a scientific proposition specific to the case in question. So if we apply this to the single immunoassay test and the expert evidence around that, the prosecution would have to produce an expert that understood how the immunoassay specific antibody-antigen binding mechanism worked, what the cross-reactivity potential was between human insulin and synthetic analogues, how to differentiate endogenous and exogenous insulin, and the relationship between insulin and C-peptide measurements, specific to the case in hand. And they would need to document the variability between the Roche test and other immunoassay platforms. They would need to provide a standardization issue across laboratories, and they would need to provide confirmatory tests using different methodologies. And we all know that none of that was provided during the Letby trial, nor considered by the Court of Appeal. So we could be pretty sure on the Daubert rule, the Kelly rule, Rule 702, whatever, in the state of Texas, Lucy Letby's insulin cases would never have reached the jury because there are no standards by which the Roche immunoassay test has been measured in preterm neonates, taken while dextrose was actually being administered at the same time, given without regard to standardization of how various plastics and giving sets would absorb the insulin, etc. None of it would have passed the Daubert test or Rule 702 in the United States. So Letby's cases of the insulin babies would have been dismissed as well. So we're left only at this stage now, before the jury has heard anything, with the error embolism cases. So if we look at the Hernandez case and Rule 702, the Daubert rule, and the appellate court interpretation of that in the state of Texas, Dowey's single theory of error embolism would never have reached the jury. The Letby defense, don't forget, argued that Evans and the prosecution experts had chopped and changed the criteria as much as required to fit the available evidence, and that inconsistency alone would fail in the Texas courts, because the technique has to be properly applied on the occasion in question. And the appellate court in Texas put it very well when they said that the trial court hearing, that was Letby's original trial, is the main event for the Daubert-Kelly gatekeeping hearing. It's not a tryout on the road to an appellate scientific seminar. So if we look at the case-specific circumstances of the allegations against Lucy Letby, that she injected error into babies, the expert witness, that is Dowey Evans, would have been required to state how he was able to determine, number one, that there was any error there at all, number two, that the error came from a syringe by Lucy Letby's hand and didn't come from the mechanical ventilator or from the many IV lines that were in place at the time, or indeed the CPR. And because, as I've already said, in 89% of cases in one of the biggest studies done on error emboli in preterm babies, 89% of babies who had CPR had error in the system post-mortem. So this would have presented an insurmountable hurdle for the storyteller-in-chief, Dowey Evans. He would have had to explain what the error rate was for diagnosing error emboli by the use of a chest x-ray post-mortem. And the error rate for that is so high, everyone would have probably been rolling around the floor laughing. So instead of a peer review by Sandy Bohan, the Texan court would have required Evans to explain how he could deduce from non-specific skin discoloration the presence of error embolism, the origin of the error embolism, and thus the validity of his entire theory. The court would also have required him to explain how sensitive X-rays, particularly post-mortem X-rays, are to the detection of ante-mortem venous error embolism, case-specific to each of the babies. And given that, in the case of baby C at least, he changed his mind on the stand, the appellate court may even have locked him up. Evans would have had to explain why baby A, for instance, died from an error embolism given by Letby 25 minutes earlier. he would have had to explain how a Venus air embolism can create localized skin discoloration when it can't, because the oxygen in that air embolism, as I've explained before, would have been taken up by hemoglobin, put into the general circulation, and would not have localized effects. And even if it did have localized effects, the human eye would not be able to see them. Dowie Evans would have been hung up by his gonads had he tried any of this in a Texas court. So the jury would never have heard any of his nonsense. And thus, it is very unlikely, if Lucy Letby lived in Hereford, Texas, that she would have ever faced a jury. It is more likely that she would have been promoted gradually over the years until she reached a very handsome wage, a purchasing power parity of about 125 grand a year. Now, there have been 2 incident cases that I can find in the state of Texas. Janine Hanna versus the state of Texas, where she was also found guilty of proven financial impropriety, in other words, stealing from her victims before she killed them. I'll leave you a link to that to see how complicated that case was, but it certainly wasn't resolved on the basis of a single insulin C-peptide test. And the outstanding case, which is going to be difficult to try, but is due to be heard in 2025. And as far as insulin poisoning in Texas goes, that's as much as I can find. But I have no doubt whatsoever in my mind that when you look at the Daubert rule and when you look at the petty little rules that they have in the UK system for determining the validity and seriousness, really, of scientific evidence, they're miles apart. There are currently 597 jobs open for neonatal nurses in Texas, and the process of actually getting a green card to go there and work and probably eventually becoming a United States citizen for a UK citizen with such special knowledge is relatively straightforward. So for all you young people that might be listening to this, have a look around you. You only get one chance at life. If you have a special skill that you have worked hard and sacrificed to obtain, perhaps your future doesn't lie in the UK. Perhaps you should consider taking a job in Texas. Yes, there'll be lots of other trouble, but there always is in life. But you can be guaranteed that you're always going to be safe from predatory people of the kind we talk about in this podcast. My daughter, a musician as well, once went to Boston, to the Berklee College of Music, and I was heartbroken. Poor me. She had a whale of a time, and the funny thing was, because of this little device called an iPhone and an app called WhatsApp, I ended up spending more time with her than I ever did or ever could at home. So I'm just saying, nurses are valued in other places. They're not valued in the UK. They'll pay you more, give you better benefits, look after you. So why not think about it? Because until nurses in the UK start voting with their feet, no one's going to listen to you. And you're going to have to put up with the same old crap day in and day out. The UK wanted to bring in a Daubert rule or a Daubert system to streamline all of this scientific evidence, but it didn't. So this is going to happen again. Somebody else is going to fall foul of this appalling system that can just make up evidence as it goes along, that can produce experts who can sit in the box and change the story from their reports, and it is permitted that the jury can consider this. I find it despicable, but who am I? So another day, goes by Lucy Letby looking out through prison bars in the UK, a supposedly civilized country. Unbelievable. So we'll leave it there, and for what it's worth, it seems that other people have thought these things through, and we'll keep on podcasting until she gets out, and we'll see you in the next one.